Stephen A. Williams, president and founder of the creditrepairshop.com. And in today's video, we're going to talk about some of the Supreme Court decisions that you need to be aware of because it's going to affect you if you find yourself in a situation dealing with a debt collector or even an original creditor, or with a company who buys your debt, that is one finance company to another finance company. You're going to want to listen to this video, watch this video. Before I get started, though, boy, we just had an election, and how quick stuff changes. Like, I was shocked. Like, almost all of my vendors, like at one time, all of my vendors, I get these emails and they're like, we're going to be increasing the rate on this. We're going to be increasing your rate for utilizing your invoicing software. The credit card processing company increased their rates. And I'm like, what the hell? Like, why do they think that we just go through all of this stuff so we could lower the rates, supposedly with all of this inflation stuff. And now all of these companies like hitting the businesses up and gonna blow up the rates. And then what is that gonna do? Like, I literally this is what I got here. I'm gonna call the roll call. Credit card processing company. They already foresee there was this little issue going back and forth on what they could charge us as business owners. Like, there was a percentage for debit cards. There was a percentage if someone did a PIN code or did a credit, like all of these. And you've seen those fees where you'll go into a store and they'll be like, well, if you don't spend this amount, we're going to increase it. These damn companies, even like, I would eat it. With my companies, I would just eat it. Man, the way that they just threw these fees out at us now, I got to add on the percentage. I'm going to have to increase what we charge for services for any of my companies that take credit cards. I'm going to get into the fee game because it's ridiculous. And then I got my liability insurance statement last year. Now, this is just straight like umbrella liability, not like something huge. It was like $2,300. Right now, it says, oh, I got it in my pocket. I put it in yellow. $3,416.69. I'm like, what changed from last year? They have me type in this thing and they say all of this. Did the revenue go up? Or like they give you this range, number of employees, this range, no claims. I had no claims, no court stuff, no problems like that. And usually it would just either stay somewhere around the same, and they've even lowered it. Raised it to $3,400, so more than $1,100 more. And I'm like, what are you doing? Like, what justified that? And then people be like, well, go shop around and do this and that. Okay, I guess I got to do that. It's just like a disruption. I could be, having relationships with companies and then we just keep moving forward, but I guess I'm going to have to do that. That's where we're at. My bond insurance went up. So liability, bond insurance, credit card percentage rates. It's like all of this stuff. And then some people will say, well, why don't you move to another processor? Not every processor allows my type of service to be processed on their platform. So it's not like I have like all these huge choices. Like, I can't go to Square, can't go to PayPal, can't go to Stripe, none of those. No, they don't accept them. I have to go straight to bank. That means that I have to put my financials in a financial package to show that I'm sound. And then the bank will allow this type of processing to happen because they consider it high risk. But that's just me, as a business person, this is the way I think as a business person. I'm just letting you know what I go through. Sometimes people think that it's just all, cake and ice cream. This is some of the stuff that I got to go through. To be able to pay my employees, to be able to make sure that they have a standard, to not have to go and cut people or to cut wages, cut salaries. these are the things that business owners have to go through. So if you're looking at becoming a business owner, or you are a business owner, I understand what you go through. So now let's get to it with some of the decisions that have came down. A crazy one that I thought, why would this even be at the Supreme Court? Why would it even raise to the level? Like, it should just be like a no-brainer answer. Well, Midland Funding had brought a case to tried to sue an individual where their documents were in bankruptcy. It was in the bankruptcy matrix. When you file bankruptcy, there's going to be a matrix, and any debts that are in there, hands off. Nobody can contact you. Creditors have to stop calling. It's like game over. Once the bankruptcy goes through, it's discharged, it's all over. Well, Midland accidentally, I mean on purpose or accidentally, somehow ended up suing an individual for a debt that was in their bankruptcy matrix. And this case was the actual case was back from 2017. But this was in one of the Supreme Court's dockets where they made their decision on it. Over this court that we have now, and they stated in there that even though the majority of them, majority reasons that such a claim is not false, deceptive, or misleading under the Fair Debt Collection Practices Act, as the bankruptcy system allowed for objections to the state, to the claim. So what they're saying, see, this is the thing, this is crazy. They're saying that because the individual had a right to challenge that the debt should not be in, that they should not even have brought a suit to them against them because it was in bankruptcy, that the individual did not have a right to sue them for breaking the Fair Debt Collections Practices Act by trying to sue someone for a debt that they legally cannot sue them for. Because it is against the Fair Debt Collections Practices Act, like this is the law, states that you cannot bring any lawsuit against an individual for a time-barred debt that is past the statute of limitations to collect. You can try to collect on it, but you can't sue them. Any debts that are in bankruptcy, that have been discharged in bankruptcy, definitely you can't. This individual filed a lawsuit saying that they should have known this, that even when they were told this, that they should have, I don't know if the individual wanted them to say, okay, hey, we just admitted we made a mistake and we will pay for that violation, which is something that they usually do because they're like caught red-handed with that violation. The Supreme Court said that, no, you cannot sue them if they do that. That's what they said. Don't take my word on it. Go to the Supreme Court. You can see all of the rulings. Go to Midland Funding LLC versus Johnson. This is one that I spoke about before, but I talk about this one because this is one that is very concerning to me. Very concerning to me. Because the court determined in Henson versus Santander Consumer USA, the Supreme Court determined that entities purchasing default debts, so debts that are in default, like if one company buys a debt that's in default, charged off, they buy it, and then they go and they try to collect on it, that they are not under the Fair Debt Collections Practices Act if they do not go out and collect debts for other companies that they don't purchase a debt from. So let me be clear, and this is in, this was SCOTUS blog, so you can go and look at this under SCOTUS blog. Basically, if a debt collector buys debt and they do not go to another company and say, hey, you having trouble collecting on those debts, we'll do it for you. If they don't do that, all they do is buy the debt and they go and try to collect on it, they are not under the same guidelines as the Fair Debt Collections Practices Act because they will be considered the original creditor. That is very concerning. Very concerning, because let me tell you why it's very concerning. Because what we see with Resurgent, what we see with LVNV funding, Sherman Acquisition 1, Sherman Acquisition 2, Sherman Acquisition 3, Jefferson Capital, all of these portfolio recovery associates, portfolio 1, 2, 3, all of these, what they do is they set up that company to be that entity. And then they shoot it down to the debt collection company that'll do it and do all the dirty work. And then if they want to, they can shoot it right back to that company, and that company does not have to abide by the Fair Debt Collection Practices Act. What I'm seeing in action, this is what I'm seeing in action, is what the companies will do is that they'll first send it out from the portfolio company and see what action that they're going to get. And technically, even though they don't even seem to be fully comfortable with this, but they know that they have this protection, is that they don't even feel comfortable not doing a debt validation. But I have had reports where people say they did not respond to my debt validation. What they did is they sent some stuff, but they did not technically respond to my debt validation. And the reason why is because you might want to do some research and see if that company is only collecting debts that they purchased for themselves. Because if they're doing that, they lean on this Supreme Court decision, Henson versus Santander Consumer USA. They're leaning on it. You can search that at the Supreme Court decisions website, but also SCOTUS blog. They had that this big on there. Another one that was out there was the court ruled that businesses engaged solely in non-judicial foreclosure proceedings are not debt collectors under the Fair Debt Collection Practices Act, except for a limited purpose of the 1692 F6, which means the entities are exempt from the act in the broader statement, which means that they do have to show everything about the debt that they're claiming, but the way that they contact you, all of that stuff, no. And the ruling on this one was Dusky versus McCarthy and Halthus LLP 2019, this Supreme Court case. Another one was Clem and Rokiski. Supreme Court held that the Fair Debt Collection Practices Act 1-year statute of limitations begins when the alleged violation occurs, not when it is discovered. So, in regular personal injury cases, there's like a statute of limitations when, and then in some cases, there's a statute of limitations when you become aware that you had been violated. Well, the Supreme Court, and then this is in the Supreme Court cases, so you can look this up for yourself. They stated that if they violate you today and you don't know about it, the clock starts ticking today. So if any debt collector violated your rights today, the clock starts ticking today, even if you don't know about it. So if you find out on day 364, if you don't file any court action on day 364, when 365 days hits, you are out of luck. Don't take my word on it. Go straight to the Supreme Court. Kiske, Kiske versus Clem, Klemm. Look up that case. So what do we got to do as this community of, number one, where I make these videos to help you out. I make these videos to tell you what's going on. I know that you're busy. I know that you're trying to take care of family. You're trying to protect your money. You're trying to protect your assets. You're not trying to have any surprises come behind you. You are trying to get to a better place and improve your lifestyle. Spend time with your family. You know, I know potentially that that's what you want for your life. And that's why we're here. So if you have debt collectors trying to sue you, go to my website, thecreditrepairshop.com. In the bottom corner under live chat, put the information there, put the lawsuit in there. We'll tell you how you can help yourself, and we'll also tell you how we can help you. That's also if you've lost a suit and you got a default judgment against you, we'll tell you how you can help yourself and how we can help you. If you need to repair your credit, go to my website, thecreditrepairshop.com. Links are below this video. We cannot speak to you before you become a client, but we don't charge before you become a client. When you become a client, everything under the TSR, we have to remain compliant. We'll go through everything with you. If you believe that we're not a good fit with you, you can cancel and you didn't lose any money. But that's where we're at right now. But even with that restriction, we still make the time and put together the platform to be able to help you. So I hope that people appreciate that. For us to remain compliant, to be able to continue helping people, this is what we have to do. So you go to my website, thecreditrepairshop.com, you sign up, pick your plan, no fee out of your pocket at the beginning. We get you into our portal as a customer, everything signed, sealed, delivered. We do your credit report review. If you feel that you want to move forward, we move forward. If you don't, you didn't pay anything. If you have debt collectors, if you need your credit reports and scores, go to the website, your order number 3scores.com. You need your credit reports and scores. Everything starts there. Get your TransUnion, Equifax, Experian credit reports and all 3 scores. If you have debt collectors coming after you, grab my 3-pack of letters. And I got something special coming for that pretty soon. But right now, you can grab a 3-pack of letters and you can put the information in there and stop debt collectors early in the game. Those letters will work. They help save time, money, and frustration that you will have dealing with debt collectors. I do ask for a donation on those, and I do appreciate those who take the time to an effort to give me a donation on giving you those letters. Those letters really do work. Please subscribe to the channel, post your questions and comments. This is Stephen A. Williams, President and Founder of thecreditrepairshop.com. Thank you for your time.